Group 1 presents Law on Sales. Topic reporters are Grace Bation for obligations of the lessor, Carlito Aceron for obligations of the lessee, Janet Anunciado for remedies of the lessor, Anshower Baracal for remedies of the lessee, Grazel Blanco for forcible entry, Vename Celeste for unlawful detainer, Irish Kamomot for action publicana, and Rose Abiol for action reinvindicatoria. Have a fun learning!
Hi, this is Grace. My report for today is about the obligations of the lessors. In the contract of lease, what are the obligations of the lessor? The lessor is obliged to deliver the thing which is the object of the contract. The lessor is obliged to make of necessary repairs. The lessor is obliged to maintain the lessee in the peaceful and adequate enjoyment of the leased property. The law says in Article 1654 of the Civil Code, the lessor is obliged first to deliver the thing which is the object of the contract in such a condition as to render it fit to the use intended. Second, to make on the same during the lease all the necessary repairs in order to keep it suitable for the use to which it has been devoted unless there is a stipulation to the contrary. Third, to maintain the lessee in the peaceful and adequate enjoyment of the lease for the entire duration of the contract. Accordingly, the lessor has three important duties: deliver of the object, making of necessary repairs, and maintenance in peaceful and adequate position. The thing leased must be delivered in order that the lessee may enjoy or use the same. If the lessor does not do so, he can be compelled by the lessee. Also, at the time of delivery, the thing must be in a condition fit to the use intended. When the lessee rents a building, which turns out, however, to be occupied by another person, and the former cannot obtain possession, the lessee's cause of action is against the lessor for breach of contract, in that the latter violated the obligation of delivering to him the peaceful possession of the leased premises. A lessee who fails to take possession of the leased premises on account of the presence of third persons, unwillingly to vacate the premises because of some previous act or transaction of the lessor, should institute the action against the lessor based upon the latter's failure to comply his obligation to deliver the same. The lessor is also obliged to make necessary repairs to keep the thing less suitable for the use to which it has been devoted unless there is a stipulation to the contrary. If the lessor fails in the performance of this duty, the lessee may suspend the payment of rent or avail himself of the other remedies provided in the law. The lessor, however, is not liable for repairs and damages or deterioration caused by the lessee himself. The word repairs, in its ordinary acceptation, must be understood to apply to the restoration of things after injury or partial destruction without complete loss of identity in the thing repaired. When the lessor agrees to keep a building under lease in a proper condition but fails to do so, and the lessee vacates the building before the expiration of the lease, the lessor cannot recover damages nor rent for the unexpired terms. The lessor has also obligation to maintain the lessee in the peaceful and adequate enjoyment of the leased property. The lessor obligation to maintain the lease arises when acts terms, legal trespass, dispute, or police difficulties in the leasee peaceful and adequate enjoyment of the leased premises that in some manner or other cast doubt upon the right of the lessor to execute the lease. In this case, the lessor must answer for such legal trespass. The lessor who fails in the performance of his obligations shall be subject to indemnity for the losses and damages caused thereby.
Good evening, attorney. Good evening, classmates. I am Carlito Asron Jr. I am tasked to report the obligation of the lessee. First, we have to define what is meant by a lessee. A lessee is one who rents a property from a lessor. He is entitled to some rights and has some obligations. Most of these are specified in the lease agreement entered into between the parties and prevail unless they are contrary to the law. This means that a property was rented by a lessee from the lessor for a specified period of time. Thus, the lessee acquired some rights and obligations to use that property. Most of these rights and obligations are stipulated in the contract of lease agreed by both parties, unless they are contrary to the law, morals, good customs, and public policy. In Article 1657 of the new Civil Code, the lessee is obliged to, number 1, to pay the price of the lease according to the terms stipulated in the contract. This means that the lessee is obliged to pay the price of the lease according to the terms agreed or stipulated in the contract. I have an example here. A rented a commercial property owned by B for 3 years because the latter will put up restaurant in that area. In the contract of lease, it stipulates that it will be paid monthly for the price of 20,000 pesos, and if the lessee will terminate the contract before the contract expires without any valid grounds, the lessor shall be entitled to collect the rent up to the expiration of the term of the contract. So here, the example given, A rented a property owned by B for a period of 3 years. So A will have to pay B 20,000 pesos in monthly basis for a period of 3 years. And if the lessee will terminate the contract, so there will be, in case of pre-termination by the lessee in the contract before the contract expires without any valid grounds, the lessor shall be entitled to collect the rent up to the expiration of the term of the contract. So example, if the lessee rent the property for only 1 year and the terms of the contract is 3 years, so the 2 years will be the lessor will collect the remaining 2 years from the lessee, which is the lessor has the right to collect the rent up to the expiration of the term of the contract. If the lessee will terminate the contract without any valid grounds. But if there is a valid grounds to that pre-termination of the lessee, the lessor cannot collect the rent up to the expiration of the term of the contract. Number 2, obligation of the lessee is to use the thing leased as a diligent father of a family, devoting to it the use stipulated, and in the absence of that stipulation, to that which may be inferred from the nature of the thing leased according to the custom of the place. So this means that we will use the example given above, no? So this means that the cleaning and repairs to carpets, lighting, walls, bathroom, and kitchen features inside the restaurant, because A will have to put up restaurant in that area, no? A rented a building, a commercial building, property to put up a restaurant. So A has a duty to take care to clean and repairs the carpets, lighting, walls, bathroom, and kitchen fixtures inside of that restaurant, and even outside of it will be the lessee responsibility. The contract of lease will usually include a maintenance and repair clause that concerns the lessee duties to take care of the rented space. This is to keep the property neat, good order, tidy, which is presentable to its customers. So, the lessee has an obligation to take care of the properties inside and even outside of that commercial property rented by him. This is usually include the maintenance and repair to keep the property neat, good order, tidy, which is presentable to its customers. So the restaurant must maintain its cleanliness and orderliness of the property inside the restaurant. So there is an example of the diligent, good father of a family, taking good father of a family. And in the absence of that stipulation, to that which may be inferred from the nature of the thing leased, it will be according to the custom of the place. So in the absence of that stipulation, if there is no stipulation that there will be maintenance and taking care of it, to that which may be inferred from the nature of the thing leased. So meaning, kung restaurant, so there will be impliedly, no? If restaurant ang ginarin, so you have to maintain the good order and cleanliness so that the customer will attract or will be your restaurant will be presentable to its customers. Number 3, to pay the expenses for the deed of lease. So this means that in sales, the expenses for the execution and registration of the deed of sale shall be borne by the vendor. unless there is a stipulation to the contrary. In lease, the law imposes the obligation to pay the expenses for the deed of lease on the lessee, and by agreement, the obligation may be assumed by the lessor. So in sales, ang expenses for the execution sa deeds of sale, sa registration, usually as a general rule, it will be burned by the vendor. So the vendor will be liable for the expenses incurred in execution and registration of the date of sale, while unless there is a stipulation that the vendee will have to shoulder that expenses. While in lease, the law imposes as a general rule the obligation to pay expenses for the deed of a lease on the lessee, and unless there is an agreement by both parties that the obligation will be shouldered or assumed by the lessor. To summarize, Article 1657 of the New Civil Code states that the lessee is obliged to, number one, to pay the price of the lease according to the terms stipulated. Number two, to use the thing leased as a diligent father of a family, devoting it to the use stipulated, and in the absence of stipulation, to that which may be inferred from the nature of the thing leased according to the custom of the place. Number three is to pay the expenses for the deed of lease. So before I end this topic, let me share with you a bar questions about the lease. Here is the bar question. Let me read. The period of the lease contract of commercial building agreed upon was 3 years. The contract expired after 3 years, but the lessee still continued to occupy the property and failed to pay its rent. Is the lease impliedly renewed? So there's a lease contract of commercial building agreed upon for 3 years. So after expiration of 3 years, still the lessee continued to occupy and possess that property and failed to pay its rent. The question is the lease impliedly renewed? What will be your answer? Okay, I will give you time for about 30 seconds. Okay, time is up. Here's the answer. The answer is the lease was impliedly renewed on a month-to-month basis. Why? Under Article 1670 of the New Civil Code, if the end of the contract, the lease should continue enjoying the thing leased for 15 days with the acquiescence of the lessor, and unless a notice to the contrary by either party has previously given, it is understood that there is an implied new lease not for the period of the original contract but for the time established. Further, in Article 1687 states that if the period of the lease has not been fixed, it is understood to be from year to year if the agreed rent upon is annual, from month to month if it is monthly, and week to week if it is weekly, and from day to day if the rent to be paid is daily. The lessee obligation to pay rental does not cease with the termination of the original agreement. So in the case at bar, the lessee failed to pay the required rent. So the lessor may institute ejectment proceedings against him because of the non-payment of rentals. So nag-expire na ang contract, still the lessee is in the possession of the property. So the lease was impliedly renewed on a month-to-month basis under Article 1670. Because it states that if the period of the lease has not been fixed, it is understood to be from year to year if it is annual. If it is monthly, from month to month, it is a monthly, and week to week if it is weekly, and from day to day if the rent to be paid is daily. So lease obligation to pay rental does not cease upon the termination of the contract while in the possession of that property. So the lessee has failed to pay the required rent, so the lessor may institute ejectment proceedings against the lessee because of the non-payment of the rentals. Still, the lessee has the obligation to pay the rent. Thank you, classmates. That's the that's my topic, and I hope you have learned something in it. And with God's blessings, thank you, and God bless to all.
What are the remedies of the lessor? The law grants the lessor the right to demand payment from the sublessee for rents which the sublessor failed to pay the lessor. It is clear in Article 1652 that the sublessee is subsidiarily liable to the lessor for any rent due from the lessee. However, the sublessee shall not be responsible beyond the amount of rent due from him, in accordance with the terms of the sublease, at the time of the extrajudicial demand by the lessor. Payments of rent in advance by the sublessee shall be deemed not to have been made so far as the lessor's claim is concerned, unless said payments were effected in virtue of the custom of the place. But this applies also to the lessee himself. Where the lessee fails to pay on time the stipulated rents, the lessor has the following right or remedies that can be availed of. He has the right to rescind the contract. He may recover the unpaid rents and eject the lessee. Upon non-payment of rent by the lessee, the lessor may elect to treat the contract as rescinded and thereby determine the right of the lessee to continue in possession, and his right to recover possession may be enforced in an action for unlawful detainer. Another remedy is to recover the unpaid rents. He can bring an action of unlawful detainer to recover possession of the premises and the rents or fair rental value. And the worst remedy is to eject the lessee. Article 1674 provides that in ejectment cases where an appeal is taken, the remedy granted in Article 539 of the Civil Code, second paragraph, shall also apply if the higher court is satisfied that the lessor's appeal is frivolous or dilatory, or that the lessor's appeal is prima facie meritorious. The period of 10 days referred to in said article shall be counted from the time the Article 1673 provides that the lessor may judicially eject the lessee for any of the following causes. First, when the period agreed upon or that which is fixed for the duration of the lease under Articles 1682 and 1687 has expired. Second, when there is lack of payment of the price stipulated. Third, when there is violation of any of the conditions agreed upon in the contract. And the last one is when the lessee devotes the same lease to any use or service not stipulated which causes the deterioration thereof, or if he does not observe the requirement in number 2 of Article 1657 as regards the user of. So in the case of Leonardo Chua versus Mucha B. Victorio, petitioners here contend that they have a continued right of occupancy, paying monthly rentals which may be increased only by 25% every 4 years. They argue that the increase demanded by the respondent was in excess of the allowable amount, and therefore invalid. The court ruled denying the petition of the petitioner upon non-payment of rent by the lessee. The lessor may elect to treat the contract as rescinded and thereby determine the right of the lessee to continue in possession. And this right to recover possession may be enforced in an action of a lawful detainer.
Our next topic is the remedies of the lease. Allow me to present it with voiceover.
Necessary, NCC Art. 1662-1. Repairs last for not more than 40 days. The C is obligated to tolerate the work, although it may be annoying to him, and although during the same time he may be deprived of a part of the premise. Repairs last for 40 days or more. He can ask for a reduction of the rent in proportion to the time, including the first 40 days, the part of the property of which he is deprived. In either case, rescission may be availed if the main purpose of the lease is to provide a dwelling place and the property becomes uninhabitable. To make urgent repairs, the lessee may 1. Order repairs at the lessor's cost. 2. Sue for damages. 3. Suspend the payment of the rent. Or 4. Ask for rescission in case of substantial damage to him. Silent as to who will pay for repair expenses, the lessee may 1. Major repairs, shouldered by the lessor, and 2. Minor repairs, shouldered by the lessee. Lessor fails to make major or necessary repairs, lessee may ask for 1. Rescission of contract and indemnification for damages, or 2. Indemnification only, while the contract remains in force. NCC Art. Total destruction. 1. The lease is extinguished if the thing is totally destroyed. And 2. The lessee of the lot and building which has been totally destroyed by a fortuitous event cannot be considered as lessee of the land after the building had been totally destroyed by the fortuitous event. Rosen V. Construction. The lease is not extinguished. Lessee is given the option to choose between a proportionate reduction of the rent and rescission of the lease. The choice of the lessee has been communicated to the lessor. The former cannot change it. NCC Art. 1201. Reduction of rent is chosen. The same shall be retroactive to the date the partial destruction occurred. In case of rescission, the general rule is that it will not be granted for slight or trivial causes. Partial destruction, under the circumstances, should be important or substantial as to defeat the purpose of the lessee in entering into the contract of lease. The choice repairs. The lessor fails to maintain the lessee in peaceful and adequate enjoyment of the property leased. 1. Case of repairs, the time you meet the demand for said repairs, and the demand went unheeded. Or 2. Case of eviction, the time the final judgment for eviction becomes effective. Terminate the lease. NCC Art. 61. Notice to the lessor in case the dwelling place or building is unfit for human habitation and is dangerous to life or health. Or 2. If at the time the contract was perfected, The lessee knew of the dangerous condition or waived the right to rescind. Reduced, and may take place in a case of forcible entry, or will not be held liable. The lessee must look to the expropriator for his compensation. KOB, Manila Railroad Company, GR number 17357, June 21st, 1922. Trespass in law, disturbance in law. A third person claims a legal right to enjoy the premises. The lessor is responsible for trespass in law. Horace, 2008. Terminates the unreported lease. Lessee may demand that he be allowed to gather the fruits of the harvest which corresponds to the current agricultural year, and that the vendor indemnifies him for damages suffered. NCC Art. 1676-2. Improvements. Production of valuable improvement on the leased premises does not give the lessee the right of retention and reimbursement which rightfully belongs to the builder in good faith. Such a situation would allow the lessee to easily improve the lessor out of its property. William, 2017. So it shall pay the lessee one half of the value of the improvements computed at the time of the termination of the lease if the following conditions are fulfilled: that the lessee should have made the useful improvements in good faith. Improvements are suitable to the purpose or use for which the lease is intended, and that the form and substance of the thing leased are not altered or modified. To retain the useful improvements by paying one half of their value. The lessee cannot tell the lessor to appropriate the purchase for the improvements. The lessee has no right to reimbursement for ornamental expenses, wherein the expenses incurred cater only to the personal comfort, convenience, or enjoyment of a person. He remove them provided he does not cause any damage to the thing leased. So, if he so desires, he will retain them after paying their value to the lessee at the time the lease is extinguished.
Good day, Attorney Buna and classmates. So in this part of the report, we will be talking about forcible entry. So I am Graciel Blanco and I will report about this part. So first, what is forcible entry? So our rules of court says that a forcible entry is an action when a person is deprived of possession of any land or building by force, intimidation, threat, strategy, or stealth. So the elements of this action is that first, the person must have prior physical possession over the property, and that person is deprived from the possession of his property with the use of fists. So this is force, intimidation, strategy, threats, and stealth. And the third one is that the intruder's entry is illegal at the very beginning. The nature of this action is that it is treated as a summary proceeding, and the issue to be resolved is that who has the better right to possess the property. This means that in forcible entry cases, the issue of ownership is resolved for the purpose only of determining who has the better right to the physical possession of the property. Therefore, the issue of ownership is not final and may still be resolved in a proper action. This means that an owner can still institute another action to really prove his claim of ownership. This action could include action policiana or action rendivicatoria. So who can file an action for forcible entry? Any person who has prior physical possession of a property, whether land or building, that was deprived of the possession by fist, again, force, intimidation, strategy, threat, or stealth. So when to file the action? Actions for forcible entry must be filed against the intruder within 1 year. This date is counted from the time of illegal entry. So where can you file an action for forcible entry? Actions for forcible entry must be filed with the municipal or metropolitan trial courts where the real property or a portion thereof is located. So what are the differences between forcible entry and unlawful detainer? Although both are the same in terms of nature, since they are both summary proceedings, but they are different because of certain elements. So the first one is that in forcible entry, the entry or possession of the land or building of the defendant was illegal from the very beginning. But in unlawful detainer, the possession of defendant was lawful in the beginning. Second, in forcible entry, a demand to vacate is not required, while in unlawful detainer, a demand to vacate is required. And the third one is that the plaintiff must prove that prior physical possession of the property was his. But in unlawful detainer, there's no need to prove that the plaintiff is in prior physical possession of the property. So let's now have an example of a forcible entry case. So this case is from March 28, 2001, from spouses Ong versus Parel. So the spouses Ong own lot number 18 of Block 2 Rizal Park subdivision. The Ongs filed an action for forcible entry against Socorro Parel, this is their neighbor, alleging that through stealth and strategy, their overhang and hollow block wall was encroaching on their property. So in a relocation survey, the geodetic engineer affirmed that Parel's hollow block wall did encroach a total of 4.29 square meters into the Ong's property. In the MTC, the spouses Ong won, but Parel appealed the decision, alleging that the hollow block wall was built by the previous owner and that the construction of such cannot be equated to strategy or stealth, considering that they only knew of the boundaries of their property during the relocation survey. So without strategy or stealth, it cannot give rise to an action of forcible entry. So the issue is whether or not the encroachment constitutes strategy or stealth, which is a material element in actions for forcible entry. So the Supreme Court said that while there was an encroachment on lot number 18, spouses Ong failed to recount the circumstances as to how and where Parel allegedly forcibly entered lot number 18. Neither was there any evidence ever proffered by them to prove that Parel made or at least ordered the introduction of the improvements or construction. So, in view of the failure of the spouses Ong to allege or prove with specificity that the respondents unlawfully entered their portion of the lot, either by force, intimidation, threat, strategy, or stealth, this action for forcible entry must necessarily fail. So that ends my report on forcible entry. Thank you so much for listening.
Good day, everyone. This is Vename Celeste, and I will be reporting unlawful detainer. Unlawful detainer is a summary action for the recovery of possession of real property. Who may file? This action may be filed by a lessor, vendor, vendee, or other person against whom the possession of any land or building is unlawfully withheld after the expiration or termination of the right to hold possession by virtue of any contract, express or implied. Its essential elements are: 1. Initially, possession of property by the defendant was by contract with or by tolerance of the plaintiff. 2. Eventually, such possession became illegal upon notice by plaintiff to defendant of the termination of the latter's right of possession. 3. Thereafter, the defendant remained in possession of the property and deprived the plaintiff of the enjoyment thereof. And 4. Within 1 year from the last demand on defendant to vacate the property, the plaintiff instituted the complaint for ejectment.
To understand better, here is a case brief on unlawful detainer. In the case of Villacruz versus spouses Maximo and Susan Christensis, the court ruled that the cause of action which would give rise to an ejectment, such as in lawful detainer case, would be the expiration of the lease, and that jurisdictional requirement of prior demand is unnecessary if the action is premised on the termination of lease due to the expiration of the terms of contract. A lease has expired when the lessor already refused to renew respondent's month-to-month verbal lease. In this case, respondents failed to formalize a lease agreement in order to protect the right of possession. Their continued occupation of the property, despite the withdrawal of the property owner's consent and tolerance, deprived the property owner of her right to use and enjoy the property as she sees fit. The court wherefore granted the petition and ordered the respondent to vacate and deliver the property to the petitioner as the rightful owner. That's all for my report. Stay safe.
Hi, this is Irish Kamomot, and now let's continue with the other remedy, which is action publicana, or the plenary action to recover the better right of possession. So what is action publicana? It is a plenary ordinary civil action for the recovery of the better right of possession or the juridical possession. It refers to an ejectment suit filed within 10 years after the expiration of 1 year from accrual of cause of action or from the unlawful withholding of possession of the realty. It is intended for the recovery of the better right to possess and is a plenary action in an ordinary civil proceeding before a court of first instance, now regional trial court, and must be brought within a period of 10 years. Otherwise, the real right of possession is lost. It is an ordinary civil proceeding to recover the better right of possession except in cases of forcible entry and unlawful detainer. What is involved here is not possession de facto, but possession de jure. There are two kinds of action publicana. First, that where the entry was not obtained through feast, or what we called fraud, intimidation, stealth, threat, or strategy. This can be brought as soon as the dispossession takes place, without waiting for the lapse of 1 year. The second one is we have that where the 1 year period for bringing forcible entry or unlawful detainer has already expired. Here, the action may still be brought after the 1 year period as action publicana in the court of first instance, now regional trial court. Hence, if brought before the RTC before the expiration of the 1 year period, the action would still be either forcible entry or unlawful detainer, and therefore the RTC would not have jurisdiction. Note, however, that an action publicana, which naturally is res judicata, only insofar as one of the parties is held to have the better right of possession, does not bar a subsequent action between the same parties where one seeks to compel the other to execute a formal deed of sale over the same property to enable him to obtain a transfer certificate of title in his name and to quiet title over the same. In other words, if at the time of the filing of the complaint more than 1 year had elapsed since defendant had turned plaintiff out of possession or defendant's possession had become illegal, the action will be not one of forcible entry or unlawful detainer, but an action publicana. That's all for my report. Thank you for listening.
Action Revindicatoria. What is an action revindicatoria? It is defined as an action whereby the plaintiff alleges ownership over a parcel of land and seeks recovery of its full possession. It is a suit to recover possession of a parcel of land as an element of ownership. The judgment in such a case determines the ownership of the property and awards the possession of the property to the lawful owner. It is different from action interdictal and action publicana, where plaintiff merely alleges proof for a better right to possess without claim of title. Jurisprudence states that, under Article 434 of the Civil Code, in an action to recover, the property must be identified, and the plaintiff must rely on the strength of his title and not on the weakness of the defendant's claim. Action revindicatoria seeks the recovery of ownership, and that includes the jus utendi and the jus fruendi, brought in the proper trial court. Action revindicatoria is an action whereby plaintiff alleges ownership over a parcel of land and seeks recovery of its full possession. In another case, it is also defined as an action to recover ownership also brought in the proper regional trial court in an ordinary civil action. This action has a prescription period of 30 years. Applicability and jurisprudence. In the case of Manalang versus Bacani, the Supreme Court states that a boundary dispute must be resolved in the context of action revindicatoria, not an injectment case. The boundary dispute is not about possession, but encroachment, that is, whether the property claimed by the defendant formed part of the plaintiff's property. A boundary dispute cannot be settled summarily under the Rule 70 of the Rules of Court. The proceedings under which are limited to unlawful detainer and forcible entry. In unlawful detainer, the defendant unlawfully withholds the possession of the premises upon the expiration or termination of its right to hold such possession under any contract, express or implied. The defendant's possession was lawful at the beginning, becoming unlawful only because of the expiration or termination of his right of possession. In forcible entry, the possession of the defendant is illegal from the very beginning, and the issue centers on which play between the plaintiff and the defendant had the prior possession de facto. In the case of Regalado versus De La Peña, the Supreme Court stated that it follows that in action publicana and revindicatoria, the assessed value of the real property is a jurisdictional element to determine the court that can take cognizance of the action. In the instant case, respondents only averred in the complaint that they are registered owners of the subject properties, and the petitioner unlawfully deprived them of its possession. They did not assert therein that they were disposed of the subject properties under the circumstances necessary to make a case either forcible entry or unlawful detainer. Hence, in the absence of the required jurisdictional facts, the instant action, if not one of for ejectment, nonetheless, the court agrees that the petitioner, while this case is an action publicana, there was no clear showing that the RTC has jurisdiction over it. That's it. Thank you.